This is case number 23CR42, State of Ohio versus John Carl Knisely. This is a bail review hearing being conducted by Zoom. Mr. Knisely is appearing from the Justice Center. His attorney is Dennis Kirk. Ms. Hapner is standing in for him. The state is represented by Assistant Prosecuting Attorney Adam King. Mr. Knisely was arraigned on Wednesday without counsel, and bond was set, and therefore, pursuant to Criminal 46, the court's conducting this bail review hearing within 48 hours. All right, Ms. Abner, would you like to speak on the matter?
Yes, Your Honor. This is a low-level felony. It's an F5, and while I understand that it is a violation of the protection order, it's not necessarily a crime of violence. We would ask that Mr. Knisely's bond be reduced or be granted OR bond. We believe that the court could make a condition of that bond that he remain away from the victim in this case.
Okay. Mr. King?
Thank you, Your Honor. The state would ask for the bond remain in place. From a quick check, it looks like this defendant has 3 prior felony convictions, including a conviction for failure to appear. I would also note that the alleged victim in this case is the same victim as a previous conviction for violating the protection order. So based upon that, I would ask the current bond remain. Thank you.
Well, while these this offense is not itself an offense of violence, it does allege a violation of a protection order, which is basically all a stay-away order is on a bail. I do have that already in place in the arraignment entry, but due to the previous conviction, potential for danger to the victim, the court's going to leave the bond the same. So that entry will be filed. Your attorney will be in touch with you, Mr. Knisely. Thank you.
Thanks, sir. Have a good day, Your Honor.
All right, are you Nicholas Tillard appearing from the jail?
Yes, Your Honor.
All right, this is case number 23CR41, State of Ohio versus Nicholas Tillard. This is a bond review hearing being conducted by Zoom. Mr. Tillard appearing from the Justice Center. His attorney is Catherine Hapner, appearing by Zoom from her office. Appearing from the prosecutor's office is Mr. King. Defendant was arraigned, I believe, on Wednesday on the charge of endangering children and domestic violence. Bond was set in the absence of counsel, and so pursuant to Rule 46, this review is being conducted within 48 hours. Ms. Hapner?
Thank you, Your Honor. Right, once again, this is a low-level felony. It's an F4. Basically, Mr. Tillard was arrested for an OVI, and his child was in the car with him. We would ask that his bond be reduced or be granted OR bond, and we believe that there are conditions that the court could make in that bond, which could include remaining away from children and refraining from use of alcohol, that would sufficiently protect the public and the victims in this case. I don't believe that he has any prior felonies.
Mr. King?
Thank you, Your Honor. I would ask that the current bond remain in place. Would note that the defendant does have a prior felony conviction for illegal manufacture and also failure to comply. So based on that, I believe the current bond is appropriate. Thank you.
I do have a question. Are these? I know that there's charged on the same date. Are they out of the same incident or different incidents?
Same incident, Your Honor.
Okay. I note in the Ohio Court report, Court Network report, that defendant does have the previous convictions Mr. King referred to. Yeah, due to the nature of the offenses, court and the previous record, the court will leave the bond in place. Your attorney will be in touch with you, Mr. Tillard. Thank you. Are you doing Mr. Parks? Right, are you Thomas Jeffrey Parks?
Yes, sir.
All right, we have two cases before the court involving Thomas J. Parks, case number 22 CR 49, 22 CR 220. The hearing is being conducted by Zoom. Mr. Parks is appearing from the Justice Center. His attorney, Danielle Witt, is appearing on her phone, and appearing from the prosecutor's office is Mr. King, also by Zoom. Now, Ms. Witt, you and your client both agree to this matter being conducted remotely by Zoom rather than an in-person appearance in the courtroom.
Yes, we do, Your Honor.
And you're all right with that, Mr. Parks?
Yes, Your Honor.
Thank you. And now, since you're not in the courtroom with her, if at any time you need to talk to her, Mr. Parks, you let me know, and I can put you and her into a breakout room where you'll be just the two of you on the screen. No one else will be able to see you or hear you. And the deputy will leave the room while you do that. Okay?
Okay, thank you, Your Honor.
All right, now in case number 22 CR 49, Mr. Parks is indicted for failure to comply with the order of signal of a police officer. And I believe we have a jury trial set for March 23rd, or we did have. And then there's also failure to appear in 22 CR 220, which is also set for that time. Now, I have been provided copies of plea agreements here, Mr. Parks, which is the purpose of this hearing. As the court was informed, there was a plea agreement. The first one I'll show you on the screen is 22 CR 49, and it has your name and case number, and it says plea of guilty to count one there. You see that?
Yes, sir.
All right, and you recognize that form?
Yes, Your Honor.
All right, and then on page 3, there's a line about a third of the way down that says, I enter this plea voluntarily. Immediately below that appears to be signature of Thomas Parks, and I'll hold that up to the camera and ask you if that's your signature there as well.
Yes, Your Honor.
Okay, then in 220, I'll hold up the first page, plea of guilty form to the failure to appear charge, and you recognize that there?
Yes, Your Honor.
And on page 3, there's the same sentence, and also appears to be the signature of Thomas Parker to me. I'll hold that up to the camera, and is that yours?
Yes, Your Honor.
When did you sign these agreements, Mr. Park?
What's that, Your Honor?
When did you sign the agreements?
Yesterday.
Okay, and when you signed them, was your attorney there to go over them with you and explain everything to you and answer any questions?
Yes, Your Honor.
And did you feel you had enough time to fully consider the matter before making the decision?
Yes, Your Honor.
And is it what you still want to do today is to go forward with the plea agreement?
Yes, Your Honor.
All right, now, case number 22 CR 49 states that you are going to withdraw your not guilty plea and plead guilty to the charge in the indictment of failure to comply with the order signal of a police officer under section 2921.331B of the Ohio Revised Code, a third-degree felony. Further states that you understand that the possible prison term for that is a minimum of 9 months in prison, up to 36 months in certain levels provided by statute. There's a fine of up to $10,000 possible. There's a license suspension of 3 years to life. That's mandatory. It has to be at least 3 years, could be life. And the prison term, if the prison term is imposed, has to be served consecutively to any other prison term. Now, in case number 22 CR 220, says you're going to plead guilty to the failure to appear under 2937.99 of the Ohio Revised Code, a fourth-degree felony, and that you understand that the penalties for that could range from 6 to 18 months in prison and a $5,000 fine. Now, under the law, as I indicated on the earlier charge, it's mandatory these sentences be served consecutively, so the maximum possible on the failure to appear is 18 months. The maximum on the 49 case is 36, so that's a maximum of 54 months. You understand that?
Yes, Your Honor.
Other than these two felony charges, Mr. Parks, are you facing any felony charges anywhere else?
No, Your Honor.
And are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
Now, you're currently in the Correctional Reception Center over in Ohio, right?
I'm in Noble Correctional Institution.
Are you in Noble now? Okay.
Yes, sir.
And is that for a case from this county or another county?
Another county.
All right. So, under the law, the sentences on these cases, if you're sentenced to prison, could be ordered to be served consecutively to whatever that sentence is you're serving now, which would, of course, extend your outdate by beyond 54 months. You understand that?
Yes, Your Honor.
All right. Now, under the law, Mr. Parks, in the 22 CR 49 case involves a failure to appear. It is mandatory that upon completion of the prison sentence for that offense, that you be placed under what's called post-release control supervision. And that means that you'll be supervised by a parole officer under terms set by the Adult Parole Authority for a period of at least 1 year up to a maximum of 3 years. However, on the other case, it's optional, and that's what it's going to say in your paperwork, of up to 2 years, but it is mandatory in the 49 case. So you'll be supervised under the terms they set. And if during that period of time they determine that you have failed to comply, then the parole authority can return you to prison even though you serve the entire term set by the court for an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in that new felony could impose for the violation of that law, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. You understand that?
Yes, Your Honor.
All right, now, these are not mandatory prison terms, although there's a presumption. Generally, well, no, there's not a presumption, but under the law, it is possible that the court, instead of sentencing you to a term of imprisonment, could grant you community control or probation, meaning you'd be supervised by a probation officer for a period of up to 5 years under the term set by the court. If during that period of time the probation department felt that you were non-compliant, they would file a written notice of that with the court. There would be a hearing. If the outcome of that hearing, and you would be entitled to have an attorney, and if the outcome of that hearing was that you could not, or that you had not complied, then at that time the court could revoke your community control and then sentence you to prison for 36 months in case number 2249 and 18 months in case number 220 consecutively, plus impose a fine. You understand that?
Yes, Your Honor.
All right, now, the charge in 22 CR 49 alleges that on or about January 10, 2022 in Highland County, Ohio, you did operate a motor vehicle as defined in ORC 4501.01 so as willfully to elude or flee a police officer after receiving a visible audible signal from a police officer to bring the person's motor vehicle to a stop. And the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to persons or property. So that's a violation of 2921.331B of the Ohio Revised Code, failure to comply with the order of signal police officer with the third-degree penalties that I explained to you. Now, the failure to appear charge alleges that on or about October 18, 2022, in Highland County, Ohio, you did recklessly fail to appear as required in Highland County Common Pleas Court case number 22 CR 49 after having been released pursuant to ORC 2937.29, and the release was in connection with the charge of commission of a felony in violation of section 2937.29 or .99 of the Ohio Revised Code. So that is the failure to appear, the fourth-degree felony with the penalties that I've mentioned. Now, Mr. Parks, do you understand what it is you've been charged with in each of those cases, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
And have you discussed the nature of each of those charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty here today?
No, Your Honor.
Now, on page 2 of each agreement, there's several lines printed in bold and underlined, and I see on the 220 case or on the 49 case, I should say, there's been a little bit of a change. And it reads, defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend 12 months incarceration consecutive to the sentence imposed in case number 22 CR 220 and consecutive to the term of incarceration defendant is currently serving imposed by Ross County Common Pleas Court. Then in the other case, the 220 case, defendant shall enter a plea of guilty to the indictment. State and defense jointly recommends 6 months incarceration consecutive to the sentence imposed in case number 22 CR 49 and consecutive to the term of incarceration defendant is currently serving imposed by the Ross County Common Pleas Court. Now, is that your understanding of these two agreements?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
No. Under the law, the matter of sentence is up to the judge, not the parties. So even though there's an agreement as to what the sentence ought to be in each case, under the law, I'm not required to follow that. So if you plead guilty to these two charges, once I've heard all the information submitted, I decide that's not the correct charge, I could sentence you to prison to as much as 36 months in the 49 case, as much as 18 months in the 220 case. You understand that?
Yes, Your Honor.
Now, do you hold any license or certification from any state governmental agency that oversees any occupation or profession?
No, Your Honor.
All right, you have certain constitutional rights you must understand before I can accept your plea. First, you do have a right to counsel, and Ms. Witt was appointed to represent you. Now, that wasn't simply to work the case out, but to provide whatever defense may be available to you under the law that you would like her to provide. So if you decide that you do not want to enter into these agreements, then she'll continue to represent you and defend you, including a trial if that's what you want. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to have a jury trial in each of these cases in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, they'd be instructed on the law. And then that jury would decide by unanimous verdict in each case, meaning all 12 would have to agree, as to whether the state proved your guilt in either case. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up in writing, your right to have a jury trial, and in that case you would have what's called a court or bench trial. That means that instead of jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, in each of these cases, you have a right to confront the witnesses against you and cross-examine them through your attorney. What that means is that the witnesses would have to come to court, an open court, testify in front of you and your attorney and anyone else that's present. After the prosecutor is done asking questions, then your attorney would ask questions, the purpose of which would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Now, in each of these cases, under the Constitution and the law, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order subpoena in each or both cases that requires those people to come to court to be available to testify, even though they don't want to be involved, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Parks, in each of these cases, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence at any time in the proceedings, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And no one's even allowed to comment about it in either case, except in one situation. If there's a jury trial and you don't testify in either or both cases, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, in each of these cases, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense in each case, in the charge in each case. So what that means is that the burden of proof isn't on you in either case to try to show you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any defense at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio in each case to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged in that case, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
All right, now originally you entered a plea of not guilty to each of these charges. Not guilty plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty in these two cases, that is the opposite of the not guilty plea. The guilty plea admits the allegations in each indictment, admits that they're a crime, that you committed that crime. And that plea waives or gives up all of the rights that I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. Would waive or give up your right to confront witnesses against you and cross-examine them through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify for you in those cases, the same as the state. It would waive or give up your privilege against self-incrimination in each case, because that's what's used to find you guilty if you plead guilty. And it waives or gives up your presumption of innocence in each case, because if you plead guilty, then the state doesn't have to prove your guilt in either case. It subjects you to being sentenced immediately by the court, which is what's likely to happen. And it waives or gives up any right to file an appeal that you think you may have had up until this point in the case, or cases. Now, if I should sentence you the maximum sentence in either case, or under other certain limited circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Parks?
Yes, Your Honor.
And did you enter into these agreements voluntarily?
Yes, Your Honor.
And you still wish to go forward with them today?
Yes, Your Honor.
Now, do you have any questions about the charges or the possible penalties in either case?
No, Your Honor.
You understand them?
Yes.
Have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand them?
Yes, Your Honor.
You have any questions about the plea agreement in either case?
No, Your Honor.
You understand?
Yes, Your Honor.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter it here today?
No, Your Honor.
You understand?
Yes, Your Honor.
Is there anything you would like to speak with your attorney about before we go any further?
No, Your Honor.
Do you have any questions about anything I've explained?
No, Your Honor.
Then is it your decision to go forward and plead guilty pursuant to the terms of these plea agreements to the charges in these two cases?
Yes, Your Honor.
Then as to the charge in 22 CR 49, which reads that on or about January 10, 2022 in Highland County, Ohio, you did operate a motor vehicle as defined in ORC section 4501.01, so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to persons or property, in violation of section 2921.331B, charge of failure to comply with the order of signal of a police officer, third-degree felony carrying a possible prison term between 9 and 36 months, in increments provided by law, a fine of up to $10,000 and a mandatory license suspension of at least 3 years up to life. How do you plead?
Guilty.
Then as to the charge in case number 22 CR 220, which alleges that on or about October 18, 2022 in Highland County, Ohio, you did recklessly fail to appear as required in Highland County Common Pleas Court, case number 22 CR 49, after having been released pursuant to ORC 2937.29, and release was in connection with the charge of commission of a felony, violation of section 2937.22, .99 of the Ohio Revised Code, a fourth-degree felony, failure to appear, hearing possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendant was deprived of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. The plea is accepted and ordered filed in each case. Defendant is found guilty in case number 22 CR 49, a failure to comply with the order of signal of a police officer, and in case number 22 CR 220, failure to appear. Now, inasmuch as Mr. Parks is currently serving a prison term, and there's a stipulation as to the length of the prison term that should be imposed, the court will go ahead and proceed with sentencing. Mr. King, on behalf of the state.
Only was continued the plea agreement, Your Honor.
You need a jail time credit there, Ben. Ms. Witt?
Yes, Your Honor, we also ask the court to follow the joint recommendation. Mr. Parks is currently serving a prison sentence, and he will not be released until January 28th is his expected release date. So we feel that this sentence is appropriate and amenable to that.
All right, Mr. Parks, anything you'd like to say?
No, Your Honor.
What's your conviction for from Ross County?
Advance.
Okay. I assume you must have picked that up when you got arrested on this charge? When you, did they arrest you on Arcapius and then get you for that, or was that a different charge altogether?
No, that was a different charge back. That was one back about a year and a half ago.
Oh, okay, all right. All right, well, with regard to case number 22 CR 49 then, it is the judgment order of the court that you be and are hereby sentenced to the Correction and Reception Center in Orion, Ohio for a period of 12 months. And according to the sheriff, you have 25 days of jail time credit from July 4th until July 29th of last year, and you'll be given that credit on that case. Now, that sentence is ordered to be served consecutively to the sentence I'm going to impose in case number 22 CR 220, as well as to the sentence in the Ross County Common Pleas Court that you're currently serving. The court will find that these offenses were apparently committed while you were awaiting trial on those other cases, but they were also committed as part of one or more series of conduct. Case number 220 was definitely committed while you were awaiting trial on 49. And the harm that is caused by these separate offenses is such that one single prison term will not adequately reflect the seriousness. The sentences that are being imposed are relatively minimal compared to the maximum possible and are therefore not disproportionate. And your history of criminal conduct demonstrates that this is what's necessary to protect the public. Now, in case number 22 CR 220, the court sentences you to a period of 6 months consecutive to the sentence imposed in case number 22 CR 49 for the same reasons that I've just described, as well as consecutive to the term in Ross County, from Ross County for the same reasons. With regard to case number 22 CR 49, upon completion of this prison term, Mr. Parks, it will be mandatory to be put under post-release controlled supervision for a period of at least a year, then up to a maximum of 3 years. You'll be supervised by a parole officer. If the APA decides that you have not complied, they can return you to prison, make you serve an additional period of up to 9 months for one violation, up to a maximum of half of the prison term that was imposed for both violations. However, if you commit a new felony, then in addition, whatever sentence the judge in a new case could impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year or whatever time is left on the period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively, the sentence in the new case. Now, and with regard to case number 22 CR 49, it's ordered that your driving privileges be suspended for a period of 3 years beginning today. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered in each case. If you fail to make payments or payment arrangements or to pay these, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then upon completion of your prison term, not while in prison, but once you get out, the court could permit you to do community service and give you credit for each hour you work. In an hourly rate set by the court, each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded back to custody then, Mr. Parks. Thank you. All right, this is case number 19 CR 235, State of Ohio versus Ernie R. Haskell. You're Ernie R. Haskell appearing there from the jail?
Yes, sir.
Dan, I'm going to need a jail time credit on you. All right, this hearing is being conducted by Zoom. Mr. Haskell was put on community control for aggravated possession of methamphetamine, a 5th-degree felony, back on October 8th of 2020. The court has received a notification from the probation officer Parr from drug court docket filed on February the 7th. He was notified of those allegations, and his attorney, he was appointed counsel, Ms. Witt, and the matter was set for hearing today. Now, Ms. Witt, do you and your client both agree to this hearing being conducted remotely by Zoom rather than an in-person appearance?
Yes, we do.
You're all right with that, Mr. Haskell?
Yes, sir.
All right. Now, Mr. Haskell, since you're not seated in the courtroom next to your attorney, if at any time you do need to talk with her, you let me know, and I will put the two of you into a breakout room. It will be just the two of you talking. No one else will be able to see you or hear you, okay?
Yes, sir. Thank you.
All right. Now, Ms. Witt, have you had an opportunity to review the allegations that were filed on the 7th of February against Mr. Haskell?
Yes, Your Honor.
And is there going to be a hearing or an admission?
He will be admitting.
Okay. The notification was filed on February the 7th, Mr. Haskell, so I'm going to go over it. It alleges that you have violated their community control order, specifically Rule 2, on 5 times. First time, 12/16/22, failed to report. 12/22, failed to report. 1/5/23, failed to report. 1/19/23, failed to report. 2/2/23, failed to report. Then as to Rule 7, 26 counts. 12/1, failed methamphetamine, ecstasy, and kratom. 12/6, failed to call in. Count 3, 12/8, failed a drug test for methamphetamine, ecstasy, kratom. Count 4, 12/10, failed to call in. 12/11, failed to call in. 12/13, failed to call in. 12/15, failed a drug test for meth. 12/16, failed to call in. 12/19, failed to call in. 12/25, failed to call in. 12/19, failed for meth and kratom. On 1/3/23, failed to call in. 1/8/23, failed to call in. 1/9/23, failed to call in. Same thing on 1/12. 1/16, I'm sorry, 1/19. 1/22. 1/24. On 1/26, you failed a drug test for meth. On 1/27, failed to call in. 1/30, failed to call in. 1/31, failed to call in. 2/23, failed to call in. 2/5/23, failed to call in. 2/6, failed to call in. 2/7, failed for methamphetamine and MDMA and kratom. And then Rule 8, on or about 1/12/23, tested positive for alcohol. So those are the allegations, Mr. Haskell. And in the event that it's found that you have failed to comply with these conditions, one of 3 things can happen. I can continue community control under the same conditions, continue it under additional conditions I think are appropriate, including extending it to 5 years. Or the third and most serious is I can terminate you from the drug court docket, revoke your community control, sentence you to 12 months in prison, and fine you $2,500. Do you understand the allegations against you?
Yes, sir.
You understand the possible consequences of an admission?
Yes, sir.
You understand you have a right to have the state prove these charges by presenting evidence and having your attorney cross-examine them?
Yes, sir.
Okay. Has anyone promised you anything or threatened you in any way to get you to do this?
No, sir.
Right? You have any questions at all then about what I've explained to you?
No, sir, I don't have any questions, but I'd like to say something.
Well, once we get to the point of making the decision as to what's happened, then you can do that.
Okay.
All right, so do you admit then the allegations?
Yes, sir.
All right. Anything from the state regarding disposition or probation?
Your Honor,
Got the
the
jail
state
time
is
credit
requesting
then?
the defendant be sentenced to STAR. We contacted the probation department earlier this week and asked their position. Mr. Parr said that he would have to get with the treatment team and then let us know. According to Ms. Witt, Tanya advised her that she has secured a bed for him at TCC today or tomorrow.
All right. Ms. Witt?
Yes, Your Honor. We do ask for Ernie to have the opportunity to go to TCC and to remain in drug court. It's my understanding that he was doing well for a period of time and pretty much fell apart for a brief period, but understands the consequences of those actions and wants to speak for himself on that. Or in the alternative, if the court does not permit him to go to TCC, that he be allowed to enter STAR.
All right. Mr. Haskell, what would you like, anything you'd like to say?
Yes, sir. Thank you. Your Honor, you see me the best that I've ever been. Like the last 3 years, I've accomplished a little more about myself than I had the previous 20. And if I could ask for anything, it'd be, I know I'm messing up. I'm losing my home. You kind of know how much that messed me. I lost everything I got. Believe me, this mistake will not happen again. And I just wish you would allow me to continue my treatment mental health at TCC. And I'll give it my all. I'll give you my word I will. This mistake won't happen again. I've lost everything once again, but it's my fault. I take responsibility for it. I've done it. And that's pretty much it, sir. I'm a little nervous, but that's it. I thank you.
Where did you complete residential treatment previously?
ACM.
Okay.
I was doing the best I've ever done in my life.
Well, I know. I mean, I've been there. I've heard it all, and that is true. But you've also had several other relapses, and moved back into transitional, and they've worked with you, and then we have these last 2, almost 3 months of things that just spiraling out of control, and at some point, Mr. Haskell, and you've reached that point. Court just has to set its foot down and say that's enough, because we all know relapse is part of recovery, but this is ridiculous. And if I sent Miss Corlonis to prison this week, the same thing. Got tired of her excuses, and I'm tired of yours. And I know that you were doing real well, and but again, it was you've had opportunity after opportunity. And we have spent so much in resources and time with you for almost 3 years, 2.5 years, and you're back to square one. And we've invested all that time in you, and unfortunately, it just hasn't taken. And so the court is finding that you're not amenable to community control, and I'm revoking you from the drug court, and also revoking your community control. It is the order of the court that you be sentenced to a period of 9 months at the Correctional Reception Center at Orion, Ohio, and according to the sheriff, you have 45 days of jail time credit on this charge, and you'll be given that credit. Now, upon completion of the sentence, it is possible the adult parole authority will put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a probation or parole officer on the terms they set. And if they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to half of the prison term that I've imposed. However, if you are convicted of a new felony, then in addition to whatever sentence the judge in that new felony case imposed upon you, the judge is also authorized to sentence you, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, then that sentence must be served consecutively sentenced in a new case. You're also ordered to pay the court costs, which judge will grant you execution's order. If you don't pay that or make payment arrangements, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, other assets that you may have. If that doesn't collect it, then once you get out of prison, not while you're in prison, but once you get out, you'll be permitted to do community control or community service in this case, in this county, and be given credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. And Mr. Haskell, I mean, I'm not happy that I'm doing this, but I don't feel that I have any choice. You know, you have just pushed the envelope way too far as Ms. Corlonis, and you know, I just can't put up with it. I hope that you will do this on your own, but as you know, it's you. You know, everybody in the treatment team, the court, and everyone else has just given you every opportunity repeatedly, and you haven't been able to follow through on a permanent basis. And it's on you. And if you're serious about what you're saying when you get out, there's still help available out there, but you got to want it. And, you know, you got to stick with it. It's not just enough to be wanting it while you're in a residential setting and being controlled every day. You've got to do it on your own. And, you know, the extent of all these violations and what's been going on shows that you haven't got there yet. I hope you do get there before it's too late. All right. Anything further from counsel?
No, Your Honor.
All right, you're remanded to custody. All right, officer. All right, are you Christopher B. Nichols?
Yes, sir.
All right, this is case number 19, CR 182, State of Ohio versus Christopher B. Nichols. Mr. Nichols, you were put on community control originally on February 25th, 2020, with some additional conditions on 10/27/22 for the offense of failure to comply. There was a notification filed on March the 9th. I should say that there was an entry filed on 12/13 of 2022 that told your time because you were an absconder. And then there was a notification filed yesterday that alleges that you have violated those entries, specifically Rule 2, failing to report since November 1st of 2022, Rule 15, failing to pay financial sanctions ordered by the court, and then the supplemental entry of 10/27/22, you failed to comply, provide documentation compliance with FRS aftercare. Now, you are entitled to have a hearing on these allegations in which the state's required to prove that you have committed these violations, and you have a right to have counsel to represent you, and I see you have filled out your financial disclosure form. Is everything on this form correct?
Yes.
All right. Now, you're down at the treatment center there.
Yeah, TCC in Michigan.
When did you go there?
I've been there around 50 days.
Okay. All right, well, I will go ahead and appoint counsel to represent you. I believe your attorney was Mr. Wagner.
Yes.
All right. Are the bed's still available for you there at the counseling center?
They're holding it, yes.
All right, well, I'm going to release you in your own recognizance then, on the condition that you remain in treatment
Yes, sir.
until the completion of this hearing.
Okay.
And you'll have to pay a deposit of $171 within 30 days to the clerk for the statutory required fees. When you get out this morning, you'll need to meet with the probation department as well.
Okay.
We will set this for an evidentiary hearing April the 6th at 2:00 p.m. All right, so as soon as you get out, you report to the probation department. You're probably going to notify TCC,
Yes, sir.
so they'll probably call them, and somebody will come out and get you.
Sir?
Yes.
I actually have a van that will be at the jail at 10 o'clock to pick up others.
Oh, okay.
We can meet with him there, and he can get on that van and go right back to TCC.
All right, great. All right, that's what needs to happen. All right?
Thank you.
Thank you.